You are listening to a Difference for One podcast, episode number 42.
I'm Michelle.
I'm Nicole.
I'm Charisse.
And I'm Cami.
We are the English sisters.
We come together to share life-changing methods of improvement through a variety of topics.
We hope that above all, these discussions will help you feel that Jesus Christ is making a difference for you, the one. And we also hope that our podcast will inspire you to find simple ways that you can make a difference for one.
Hey guys, welcome back to another episode of A Difference for One. It's Michelle with you today, and I'm joined by Jim Schleiffarth. Welcome, Jim, and thanks for coming on today. I invited him to talk to us about wills and trusts and all things legal as far as having things in place if anything should happen to you as an individual or a couple, and just having everything squared away for all of the what ifs. So thank you so much for your time and for joining us today.
Yeah, glad to be on. Thanks, Michelle.
Do you want to tell us a little bit about your background?
Happy to. I'm a lawyer and practice primarily in estate planning, which is wills and trusts and powers of attorney and such things. People always ask how long I've been practicing, and I forget, 13 years. So I finished law school in 2007. I went to Indiana University. I had gone to undergrad at BYU in Utah, and then I'm originally from St. Louis, so Indiana felt like close to home. Even though it was 4 hours away, it was a kind of welcome Midwest move. Mm-hmm. And then after law school, I worked for a real big firm for a couple of years. I opened up my own practice in 2008 or 9. I should know that. That's like critical stuff, and I always forget. But it's been about 11 or 12 years.
You got enough experience under your belt. That's what we really need to know, right?
We'll be back after this quick break with a message from our sponsors.
Okay, so let's just jump into some questions about wills and trusts and, like you said, powers of attorney, which I don't really know what that means, so we really need to cover that one. So tell me what the difference is between a will and a trust, and what would you say people need wills versus trusts, and what do they do for them?
Yeah, one thing I like to start with is really the primary similarity between the two. Ultimately, they're both about what happens to your things, your assets, when you pass away. And they both effectively direct where those things are distributed. Is that to your spouse or your kids or your favorite neighbor or a charity you want to give to? Both do that. They do it in different ways. A will, we often think of as the building block of any estate plan. Directs where your property goes. Most people are probably most familiar with what that is. It pops up in movies, inaccurately a lot, but pops up in movies. And a trust has some advantages over a will in the way that it distributes. And the big two, and we can certainly dive in as deep as you want to these, but one is it avoids probate. So probate's the court-supervised process of facilitating the moving of assets from a deceased person to who's in their will. So a will goes to probate. Trust avoids probate. And that's one of the big advantages. And then the other is that it gives you what in a sentence or two I would describe as lots of flexibility and creativity with what you want to happen. Whereas a will is about, this goes to a person here, that's it. Trust, it can be applied in lots of ways, but it gives you more flexibility.
And more depth to what you're
Yeah.
doing. So what is probate?
So probate, let's say that I like to use the example of real estate because most of us can kind of wrap our heads around that and understand. So let's say a couple owns real estate. One of them passes away and then the other one passes away. And they want their kids to have property. And maybe they even have a will that says that the house goes to their son, Tom. Well, who can sign the deed to the property, transferring it to Tom? Both parents are deceased. Tom can't sign that by simply the fact that he says that he's their child or that he is or that the will says anything. Someone has to give someone else authority to do that. Well, the court gives authority to whoever's named in their will or otherwise applies and is appointed as what was once called an executor. Is actually called a personal representative. And that person then has authority to carry out what's in the will. And so that process is probate. And there's more to it than just transferring a piece of real estate, right? But conceptually, it has to do with the court giving someone, the personal representative, authority to carry out the will, pay off creditors, distribute assets, make sure that goes where it needs to. And that's a multi-month process. One reason we often look to avoid it is there's time and headache and cost.
So if everything is set up the way that it's supposed to, going through the right channels, you can avoid probate, or you still have to go through all of those details after a person passes away?
Yeah, that's the big difference between a will and a trust. A will, there's nothing in thoroughness you can do to keep it out of probate. A will does what it does only by probate. No matter how you intended for it to not go through probate, it will, because there's no one has authority to transfer, in our little example, that house, even if it's clear who it goes to. Someone has to have authority to sign that deed. And so probate is the way that happens. A trust avoids that. And so a trust keeps you out of probate. And that's a common misconception of people I work with all the time, thinking not having a will lands you in probate. Right. Will keeps you out of probate.
I would be one of those people.
Simply untrue. Well, now you know.
Now I know. And you said it's not called an executor anymore. What is it called instead?
A personal representative. In some states, they call it an executor. There's a few different names, but in Missouri, it was once called an executor years ago. But it's a personal representative. Most people know that term executor more, so I always reference it because it sort of rings the bell with personal representative.
And then a trust would establish more firmly who the personal representative is and what they need to carry out.
The way that it plays out, and the best way to understand it, is a trust creates a separate entity. Kind of like if you created an LLC or a corporation. It exists, and the law recognizes it as something separate from its shareholders. Well, of course, a trust is not a company and its shareholders aren't involved, but you're creating this entity in the same sort of way. And you do that by signing a trust agreement. And there are a few roles within a trust. A trustee, the trustee's in control. They're the manager of the trust. And there's the beneficiary. That's for whom the trust assets are being held. And if you, Michelle, were to create a trust, you would probably want to name yourself as the trustee and the beneficiary so that you own it, you have full control, but you're putting it in this separate entity. And then it avoids probate because when you pass away, within the trust agreement, you've named a successor trustee. So there's no need for a court to say who has authority to do what. When you pass away, you've named your friend, we'll name her Sarah, and Sarah is the successor trustee. And so there's no need for the court to be involved at all. So we're avoiding probate. So the big advantage to a trust over a will is that it avoids probate. And the way that it does that is you're creating a separate entity, a trust, into which you transfer the things you own. So you would, for example, sign a deed moving your house into your trust, the trust over which you're the trustee, the manager of the trust, and the beneficiary. So when you're alive, not a lot is changing from like a just intuitive control perspective. It's all yours. But you're creating this trust and putting it into there instead of holding it in your own name. And when you pass away, there's no need for the court to be involved. So probate just isn't necessary because those assets belong to someone to trust who didn't die. Yeah, you died. Like when a CEO of a company dies, the company doesn't spiral into probate. There's just a new CEO. And so with the trust, you have a successor trustee who's named within the trust document, and they're able to seamlessly have control over that piece of property, transfer to your kids. Court just doesn't need to be involved. And so probate is just not necessary. And that's a good thing.
Okay, so say you're a young family like mine, and both Mark and I were to pass away. Would you recommend that, let's say we picked a nice couple in our family that we wanted our kids to go to, and would you have a separate person that would be the new trust owner? Is that what you called it?
Trustee.
The new trustee. Would you recommend that be a separate person than the family that's going to take over raising your kids?
It's a balancing act between efficiency and supervision. It would be more efficient to have the same people take over as in a parental role as guardians and be the trustees. I'm assuming our hypothetical trust is for your kids. It's meant for their care, and at some point they get it, but it's meant to help raise them. Well, it would be more efficient to name the same people. And so sometimes that makes sense. It becomes kind of a personal preference thing. But there also could be reasons why maybe you want someone else involved. I mean, it could be that one person is good with money and one person's good with parenting. or their family is such that that's more conducive to taking on 5 more kids. But it could be too that you just want two different people involved, that you want the trust, the parents not to have the purse strings too. And are they really using it? And that could be other family members are wondering what's going on, or, there's just more transparency to kind of have parents being parents and money people being money. They're paying someone else instead of paying themselves. And so it can feel more transparent and just maybe safer. Probably less, there is less risk of abuse.
Yeah. And making sure that there is still something to be left when the kids are old enough to
just managing it well,
college and all of the things to kind of start their lives off right. I guess for me, and what my husband and I have talked about, is what can we do to make sure there's going to be the least amount of family drama involved. It can be really bad from what you probably know better than I do.
It's hard to gauge always what to do because personalities are different in your family and Mark's family and my family. They're just in any families, right? They're going to vary. And then sometimes having the folks in charge of the money being different folks than those that are in charge of the kids maybe could lead to less family drama, because there's not, Bob and Susie, they've got all the money, and boy, sure seems like they're getting a nice car. I bet they're using Mark and Michelle's money, when they're not. Or maybe they are. Both are bad, right?
No one's looking at the books.
So having two different hands in there might help, because there's no ability for a trustee family member to use it on themselves, and they're probably going to either use it more responsibly for the kids, or at least everyone will see that they're using it more responsibly for the kids, even if someone else would have too. So there can be some advantages to having more people involved. Yeah. It's less efficient, but efficiency is not the only goal.
Right. Well, pulling it back a little bit, I'm just imagining my husband and I often having conversations where we're like, if we don't have something in place, the courts are going to decide who gets our kids. The courts are going to decide what happens to our money. And that is just a frightening thing to me, because they don't know my family the way I do. They might decide that so-and-so is much more suited for it, whereas I might know or feel something differently about the way that they raise their kids that's different than the way I raise my kids. And it's kind of scary to think about what could happen if you don't have some sort of a trust set in place.
Yeah, so it brings up something that I end up talking about frequently with families and clients, and that's what happens if you don't have any planning in place. On the guardianship, who raises the kids question, it would be decided by a court. Now, the flip side of that is it always will be decided by, even if you nominate someone, they still need to be appointed by the court. So if you were to name your sister and her husband to be the guardians of your kids, the judge would generally defer to that nomination. But you could imagine if it turns out that your sister is totally unfit to serve in that role, she won't be named, even if you've named them. Let's say, I always give this sort of silly, extreme example. She's in prison, or there may be a medical condition, or she's, extreme financial problems, or it could be anything, right?
Anything.
But so they won't necessarily be appointed just because, but it's more likely.
Good to know. Do they visit the home? How much background check do they do to determine if they're fit to take on the role as they're asked?
Yeah, so it would be, the standard is the best interests of the children. So there is some component there. At times, every judge is going to handle a little bit differently, but you could have something like a special person appointed to look out for the best interests of the kids. It would be something that would be determined in court and with testimony, not that it would be adversarial necessarily, but certainly something they'd really establish what's in the best interest of the kids. And, that's the standard that it probably ought to be, the kids' best interest. So if you've nominated someone, they're going to defer to that. But it could be so obvious that, like, oh my gosh, they've named this person.
Just no way.
No longer the case. It doesn't, and that's probably a good thing. You'd hate to name someone and then something went south right after you died. You probably might not want them there. So in a way, a welcome safeguard.
Yeah. Yeah.
To put a cap on it, I'd say the quickest takeaway, or the most important takeaways with respect to a trust, are the two big benefits of trust over a will. One is avoiding probate, that makes it easier. Probably more importantly is the ability to take care of kids, and kids doesn't have to be kids, it could be anyone, but to have those assets used in particular ways. A will gives it to them. And if they're young, a conservator is appointed by the court. They get it when they're 18, which is potentially terrible, right? Maybe that's the worst thing that happened. The trust allows you to be much better about how things are used. A trust is generally better than a will. I mean, I'm always careful in what I do not to say, hey, there's only one path and it costs more, right? A trust costs more. There are always different options, but a trust is essentially in every way superior.
Okay. What would you say if you're talking to your single brother that doesn't have a wife or children to leave his assets to? He may not even have a lot of assets. Would you still recommend that someone like that get a will or a trust?
Every scenario is different, of course. There are absolutely, people that are single that a trust is necessary or highly, highly recommended. If someone's in a scenario where not having kids makes the need for a trust potentially less. I mean, there are other reasons you might want to trust, but that our examples we keep falling back to with kids wouldn't be relevant. If they don't have any assets, then they probably don't need a trust. I think a will is still smart because there are things that they own, whether it's a car or a bank account. And there's some other tools that can be used, even maybe more effective than a will when someone doesn't own much and they just want it to go to one place. There are some ways to do that. But for anyone, and we can jump into the rest of these as much as you want, the power of attorney documents and a will are advisable for anyone. And it might take a simplified format, kind of an easier plan and probably cheaper to set up. But I think for anyone, it's smart.
Gotcha. I think of things sometimes relative to the accounting world. And so I'm thinking like taxes, sometimes you can just do it really easily. And sometimes you need a tax specialist to walk you through the whole process in more detail. So it probably depends on your financial situation in that case and your family and asset situation in this case. Okay, so explain to me what a power of attorney is and why you would need it.
So a power of attorney is a document by which you give authority to someone else to make decisions for you. So my first introduction to power of attorney was as a kid in, is it Rocky 3? Rocky gives power of attorney to Uncle Paulie, his wife's brother, and he loses all the money. He makes some bad investments, and I think that's why Rocky. You're looking at me like you don't watch Rocky, so that's okay. Maybe some listeners do. So Rocky's he's the prize fighter.
I've seen some. I love his song. It can really pump you up.
That's right.
But other than that, I don't know a ton about the Rocky movies.
Well, the short of it is he made a lot of money, and he gave power of attorney to a family member, and the family member lost all his money for him. And so I know that was my first introduction as a child. What is this power of attorney thing? It sounds horrible, right? So it's like it can be abused. That does, I think, underscore some risks to consider. But at its core, it's giving someone else authority to make decisions for you, and usually that's in contemplation of being mentally incapacitated. So whereas a will and a lot of the functionality of a trust has to do with after you pass away. The power of attorney is kind of the opposite. It goes up to that moment of death and not further. It gives someone authority to make decisions for you. Do things like pay your taxes, sue someone. Let's say you were injured in a car accident and you're suing, something like that, suing an insurance company or your individual who's insured by the insurance company. Or write checks is the kind of easiest example to think of who can write checks for you. But really dealing with any business, personal, legal, financial, tax sort of matters. So it's giving someone authority to do that for you because you can't.
Gotcha. So would this be your lawyer would do that for you, or another family member or someone you trust would take that over?
Usually another family member. The person named, confusingly, because to your point about a lawyer, is called an attorney in fact, which does not mean that they're a licensed attorney. It's admittedly confusing terminology. It's just what it is.
There it is.
But it is what it is. So you're naming someone to serve as your attorney in fact, and that's someone who has authority to make decisions for you. Usually in most cases, spouses name each other first, and then naming a succession of successors or backups is smart. That might be your brother or your sister or your parent or your close friend or whoever you want.
Gotcha. And so are there other things that a power of attorney will do for you, or different kinds of power of attorney, or?
Absolutely. I definitely don't prepare them as frequently, but you could have a power of attorney really limited in its scope. For example, I've had clients where we're just dealing with a certain piece of real estate. They're going to be out of the country and they want someone, not when they're incapacitated, but just all the time, to be able to handle this on their behalf, and we'll do a limited power of attorney. So the idea of a power of attorney could be really narrow, could be really broad. Usually it's really broad when we're talking about it in an estate planning context, because if you're incapacitated, you're not going to be doing anything yourself. So if you're not giving it to someone else, no one's going to be able to do it unless they go get appointed by a court. So power of attorney avoids what would otherwise be a necessary conservatorship set up by the court. And so power of attorney is a much easier way to accomplish, in large measure, the same service.
Gotcha. So if it's a power of attorney situation, is that person liable for anything that you own, or are any of their assets attached to your assets or anything like that?
No, power of attorney is only them acting on your behalf. And so Michelle, if I grant to you power of attorney to act on my behalf, you could sell my house. Now you have a duty to act in my best interest.
Or get sued or something.
Yeah, or get sued. Now, the rub with that, of course, is if you go take my money out of the bank and go to the casinos on the river and spend it all, it's not the bank's fault. So my family couldn't sue the bank. You acted seemingly within the scope of that, but they could certainly sue you, and it could even be criminal. But those aren't joint assets now. You're acting in this limited special role on my behalf, so they're not things that you own together. If, for example, you got sued for something, my house would not be something that, the plaintiff could end up having because of a power of attorney document, and vice versa. If someone were to sue me in our little hypothetical, you're not on the hook.
Gotcha.
Like your house, you're not going to lose your house because you were in this power of attorney. So it is really just an agent type role rather than being any kind of sharing in essence.
Okay. So what would you say are some basic guidelines on selecting the right person for power of attorney, or making sure your trust goes through the way it should, or guardianship over your kids?
Yeah, some of those roles vary a bit. You pointed out smartly so a couple different headings there. Who raises your kids is, for most people, more of an emotional, social, sometimes religious sort of calculation. As well as maybe, do they have other kids, and maybe even financial, how big their house is, where do they live? It's sort of more
Are
of
they going to see other family?
Yeah, it just becomes this more personal decision, right? Whereas when you're thinking about who do you want to serve as, let's say you had a trust, the trustee of the trust, those characteristics, I generally advise people: responsibility, competency, trustworthiness. Those are the sorts of things. Do they know how to manage money? Or get the right help to do it? They can certainly enlist a financial advisor or a lawyer. But when push comes to shove, are they responsible? Are they organized? In some of the roles, communication skills are good. If they're managing money for your kids and someone else is parenting your kids and they're abrasive communicators, that might not be smart. You could really have. So the ability to sort of get along with people who are family members is relevant. But I think at its most basic, financial competency, responsibility, trustworthiness, because they could take the money and spend it and they'd be in big trouble, but the money be gone. And so those sorts of responsible type characteristics are more important for something like a trustee, or that attorney, in fact, in their power of attorney is a little different for a parent.
Gotcha. And so what about if you wanted to make changes down the road? Let's say a family situation changes and you were like, oh, I thought this family might be the right ones, but now we're kind of thinking this. Is it a difficult process to change your trust around, make adjustments?
Yes and no. The no, it's not complicated part would be, yes, it can be done. So almost any document, the sorts that we've been talking about, can be changed. So a trust is, in many cases, what's called a revocable trust, which means it's also amendable. There are irrevocable trusts used in some scenarios which you couldn't change. But in most cases, all of this can be changed. But the non-simple part, it's not terribly unsimple, is you wouldn't scratch it out and change it and initial it. You would need to have an amendment of the trust. And so as a lawyer, I say not terribly complicated, fairly straightforward document, but has some formality to it. You would want to go back to your lawyer,
the right way.
Do it the right way. A power of attorney, usually you would just redo it because it's just not as involved in the document. So can it all be changed? You bet. Is that fairly easy? It is. Is it super, super simple? Maybe not quite.
You still need a lawyer.
Yeah.
Get the lawyer involved.
Get it right.
Okay. And talk about using just documents online versus involving a lawyer in this. I know you might be a little bit biased being a lawyer, but tell me the pros and cons of why not to just do it yourself. We kind of covered it before, but.
And I try not to be biased. By very definition, I have a huge bias, because the one is the livelihood of me and my family, right? And the other is not. But, looking at it objectively, I mean, the advent of accessible legal documents primarily over the internet is a really good thing. A good thing for the legal profession, I think, certainly a good thing for families and for accessibility to, reasonable legal work. So there's some real advantages. LegalZoom, I know, is probably the one I hear about the most. And I, with some frequency, get the question of, hey, can't I just do this online? And my response genuinely is always, you can, and might work maybe. There's no reason it won't. It's not that it's not enforceable, but I end up seeing the messed up versions of all of these things. And of course, things that run smoothly, I understand I may not see. But I fairly frequently have people come in, oftentimes it's with real estate, but sometimes with estate planning, where it's not done right. Either it wasn't signed right, like a will requires 2 witnesses, and maybe there aren't witnesses, or the wording's not done right, or does it have
to be notarized?
It does, and there's formalities, a will in particular, just because kind of going back in time has some of these, some feeling, seemingly kind of archaic formalities, and if those aren't adhered to, it's not valid. I've had clients that it's very clear after the fact, not clients of mine when preparing it, where they've died and they had a will prepared. And for example, in one case, it was a handwritten will, and it was very clear what they wanted, just not enforceable in Missouri. I mean, so even though it's very clear, courts take those formalities seriously, is my point, whether it's the handwritten component or something, even a typed will with only one witness.
Right.
Tough luck. Even if
and
it's
you don't find out
clear
until someone has died sometimes. And so there's not really going back in this area sometimes, right?
Yeah, absolutely not. And my philosophy, and again, I recognize, this favors me or whatever, but I really feel it genuinely is, you want to get something like this right. And so utilize someone that has the know-how and the experience to get it right. Will it cost at least a little bit more? Yeah, it probably will. It probably should. If your lawyer's charging you $200 for everything, he's probably not very experienced. He or she's probably not very experienced. So it will cost a little bit more, but it doesn't need to be exorbitantly expensive. There are good lawyers, and I try to be in this boat myself, that aren't terribly expensive. I mean, that try to be competitive on fees and reasonable on fees. And so I think in most cases it's smart to use a lawyer. But that's not to say that those printable online sort of things never work or can't work. They can, and they sometimes do.
And it's probably better than nothing.
Yeah. If
it's between this document online and nothing, let's go with the document online. But if you can get a lawyer, that's best case scenario.
It's a great description. Yeah, I would never dissuade someone. They're not doing a lot of harm. They just may not be getting anywhere. They thought they did get somewhere, and so it can be deceptive. But in most cases, it doesn't do any damage. So I think it can be a good thing.
Gotcha.
The primary purpose of estate planning is to get the planning done. But one of the side benefits of preparing a will or power of attorney or a trust, of course, the end product. But also it's the process of talking about these things. Even with a spouse, I can't tell you how many times that I sit down with 2 people and suddenly they get talking and they're like, wait, what? You'd want that? Yeah. And so being able to sort through that and figure it out, of course, getting it on paper, but even kind of the 2-step process of even deciding. The common one for younger families is, well, who's going to get the kids? And that can be contentious or difficult just to figure out. And
it's really hard.
Having that discussion. Yeah, I feel that too. I think about it with my own wife and my kids and kind of us figuring that out. So having the process of that communication is really valuable. Of course, it also needs to get the ink to paper as well.
Right.
But the process is really valuable. And then also after everything's done, people often ask me, well, do I need to give this to the person I've named as personal representative? And the answer is no. Or the successor trustee, no. But I usually tell them they ought to.
At least they should know that they have been named.
At a minimum, tell them, hey, I've named you in some roles and I keep it here. If something ever happens, come check this out, or here's Jim's card, or something like that. But in the right scenarios, it might even be a more involved conversation to really sit down and say, to your point about Dave Ramsey's anecdote, is really like flesh it out. And for some people that works, others that might not. But I think some level of communication, letting people know what's been done, is smart too.
Yeah. Do you ever run across people that don't want to talk about it. Like, I don't want to think about what happens when I die. I don't want to talk about death. This is just so gloomy that they don't want to address it.
Usually by the time they're to my office, they have cleared that hurdle by the nature of being there. But almost, and I'm not exaggerating, at least half of folks that I talk to say something akin to, we're kind of embarrassed to say we don't have anything in place, even though we're 65 years old. And I say, don't feel bad. Like every client tells me, and I'm not exaggerating, is so frequently people don't, and what it comes down to is I don't think they like to address it. And I get that. I mean, I work with it professionally a lot, but on a personal basis, I understand you don't want to think about these. How are my young, poor kids going to be taken care of when dad and mom die? I mean, that's dreadful. Yeah. And so I get it, but that is a common barrier to getting it done. Usually by the time they've called and made an appointment with me, they have cleared that barrier a little bit, but at least was a barrier for most, and occasionally continues to be. They drag their feet in the process. Yes, they came, but then they don't want to talk about it. So there is occasionally, even once they're seeing me, sometimes.
Well, and there might be some of our listeners that have had that, like, oh, I don't want to think about it, or I'm still young. And I think you're never too young to be thinking about it, especially if you're married. So what would you say if someone wanted to go about the process? How do they pick a lawyer? How do they start the process?
Yeah, I think choosing a lawyer is the most important. Well, maybe two characteristics I think are particularly important. One is, the experience and competence component, and that's maybe the most important, is someone that knows what they're doing, like any field. And what I think maybe folks don't realize who aren't lawyers, I certainly didn't until I practiced, is there's such a range of lawyers. I don't know the first thing about defending you against criminal charges in court. I wouldn't accept a criminal defense case. And if I did,
or being a divorce lawyer, or
I would be, you'd have the worst divorce that there ever was. And you would be cursing me for years because I wouldn't take it on. And I say that divorce, criminal, name about 30 other areas of law. Nope, and nope. I really don't know how to do that. I think it's easy to assume, oh, my cousin's a lawyer, he can prepare my will. Well, I mean, legally, he's unlicensed practice of law by doing it. That's true. He is licensed, but he probably is not competent, probably doesn't know what he's doing, unless that's something he practices in. So I think really understanding that, just as like you wouldn't go to
an anesthesiologist to help you with a lung problem or something.
Exactly. So I think finding someone that really, this is really what they do. And then I think communication is really important. And, some of that's like maybe personal connection and things. Everyone's going to kind of be on the same wavelength with different people. But finding someone that you really feel like explains things to you, understands what you're getting, isn't just trying to get you in the door and out the door, but really is willing to sit down and answer questions, and that you're on a similar wavelength with. I think that's really important. Not because, in some ways the product will be better because there'll be more of an understanding of what you want, but just your satisfaction with understanding that, what's going on and what the documents mean, and that you're confident in being able to have questions answered and come back to them if they, down the road as you have questions. So I think competency is of course maybe the most important, but I really think that communication and kind of relatability is important.
Okay, great. And if someone wanted to get a hold of you, what's your information if they wanted to reach out to you? And can you go across states, or are you only licensed in Missouri? And do you do it virtually, especially if anyone had COVID concerns or something and needed to meet virtually?
Yeah, I'm licensed in Missouri and Illinois. I primarily practice in Missouri for sure. I do have some clients that we kind of work in both states, but mostly in Missouri. Right now, we are doing a lot of Zoom meetings. Flashback, what are we at? 9 months now? I lose track of how deep we are into COVID time. But flashback 9 months, I had never heard of Zoom. One time I heard someone mention it in a dating app context. And maybe I think it was kind of a safe way to not give out your cell phone number and be able to kind of have a video conference. I thought, what the heck is this Zoom? 2 weeks later, it's like,
everybody knows Zoom and everyone's on it.
This was in early March that I heard this, and I had never heard of it. And, literally a few weeks later, I was like on it multiple times a day. So right now, I end up doing a lot of initial meetings, and I don't charge anything. Many lawyers don't. I certainly don't, for like an initial consultation. And so a lot of those are by Zoom now. And some people are just dying to be in person. We do that too. But we, with some precautions and things. But a lot of Zoom, sometimes just telephone conferences if that's easier. And now, at least through the end of the year, it'll probably be extended again. Missouri has allowed notarization and witnessing to occur by video too. So that the whole process can occur right now. That's not traditionally the case. You can always talk in person, but the signing needs to occur by video, and the signing needs to occur in person. Right now, that can all occur by video. And so the whole process can be totally contactless. You could be nowhere near my office. So that's a good thing. That's really helpful for people. It's helpful from a health perspective, but also just to get it done perspective.
Right.
Say you have two working spouses and a kid in daycare. I mean, very, very hard to find a time you both come into the lawyer's office. Well, you might be able to Zoom in at lunch or 5 o'clock or something. It's really, in some ways, made my work easier.
Yeah, that's great. You brought up that you are licensed in Illinois and Missouri. What if somebody changed jobs and moved to South Dakota or something? Would all of their forms and documents need to be changed and redone in a different state, or would they all still be valid in the new state?
I think every state recognizes the validity of out-of-state documents so long as they're done with the right formality. So essentially, they can cross state lines just fine. But with time, if you say, Michelle, you moved to Texas and you really moved to Texas and you're Texas.
We're going to retire in Texas.
Yeah. At some point, you think about trying to use a power of attorney document at a bank in Texas and it's from Missouri. You're going to need to consult with their legal department or something. It's like at some point you're going to want to update it per that state. You don't need to do that the second you move there. It's not that everything evaporates when you're
it's not like your
out of state.
Address forms and your license and everything that need to be changed pretty quickly.
It's not as quickly, but at some point probably do want to address it. And I probably wouldn't be able to help you because being licensed in Missouri and Illinois, you'd probably need to find an attorney that's.
All right. Those are all the questions that I had for you today. Any last tips or things we need to know, or do you feel like we covered it pretty well?
Well, my only last tip would be, and I sort of hit on this earlier, but I think estate planning, and I think this is true of lots of lawyers. I don't mean this is something unique to me, but I hear people say, that wasn't nearly as hard as I thought it would be. People say that a lot. And that's a goal for me in the process, but I don't think that's necessarily unique to me. I think for anyone, it's really not as hard as you might think it is. And so jumping in and getting good advice. A lot of attorneys won't charge anything to meet initially. So if you don't want to hire me to do something, you can still figure that out. I'm not going to bug you or pester you or be upset about it or send you a bill. So I think just kind of pulling the trigger and going for it is really smart, and figuring out what are the possibilities, what's it going to cost. I will almost promise you that it's going to be less painful than you thought, and give you a lot of not only peace of mind, that's nice, but also really have the documents in place if heaven forbid, you do need, even if you're young and healthy, if something does happen, you have the peace of mind for it, but also the reality that your kids really will be much better off.
Yeah. So if someone wanted to get in touch with you personally, how could they do so?
Well, my website is sch-law.com. or my email, jks@sch-law.com is probably the easiest way. My phone number's on the website.
Okay, great. Well, thank you so much for your time and answering those questions. That I feel like I have a way better grasp on all of the ins and outs of this stuff, because I was kind of clueless before. So this has been so helpful, and hopefully our listeners will have gotten a lot out of it as well.
I appreciate the chance to talk about what I talk about all the time. It's kind of fun for me.
Yeah. Thanks for listening today, and we will see you next week. Take care.
If you like this podcast, don't forget to subscribe and leave a review. If it resonates with you, the greatest compliment you could give is to share it with a friend who might benefit from it as well. Check out A Difference for One on Instagram for additional content. And if you have any questions, comments, a topic you'd like to hear about, or if you'd be interested in a free mini coaching session, send an email to adifferenceforone@gmail.com.